My name is Tanzil Chowdhury, and I'm a lecturer in the School of Law at Queen Mary University of London. Welcome to the second event in our Law and Marxism series. And we have another fantastic book discussion today, Dr. Mayopal's Jurisdictional Accumulation, with discussants Professor Claire Cutler and Professor Benno Teschke. The series is hosted by the Centre for Law and Society in a Global Context, specifically the Power and Capital stream. You can learn more about it in the links that I've just sent in the chat. In our last event, we mentioned some of the reasons we have launched this series, and you can hear about some of those in the start of our inaugural book discussion, the video of which is on the first link that I've sent out in the chat. However, it's worth briefly recapping on some of the objectives of this series, which I'm co-producing with Dr. Eva Nanopoulos, who sends her apologies for not being able to attend today. So the objectives of this work are still very much in progress. And we're kind of still thinking about the kinds of interventions which we think might be useful. So we're genuinely eager to hear from staff, from students, from activists about how they might think that this would be useful. But some of the ideas which were germane to our thinking when we curated this series were as follows. And first and foremost was to try reach out beyond academia and beyond the Anglo-American tradition to bring in people whose work has less visibility. We also want to bring in people from different disciplinary discussions and traditions and what they have to say about Marxist legal theory, whatever that is. So what the non-lawyers, what kinds of interventions and reflections they may have. And today is an especially brilliant illustration of that cross-disciplinary intervention. What we also want to look at is how these conversations might intersect with political education around Marxism, how that would fit in within the university space, but also beyond. And finally, to think about another stream that forms part of the Centre for the Law and Society in a Global Context, which is on art and aesthetics, and think about what an aesthetics of Marxist legal theory may look like. But as I say, we do really encourage people to send in their ideas, thoughts and reflections. So first of all, now to our fantastic speakers. First of all, the author, Dr. Mayopal. Dr. Mayopal is a senior lecturer in international relations at Oxford Brookes. Her main research activity focuses on the relationship between international law and international relations, and more specifically through practices of early modern imperial expansion, jurisdiction and the problem of legal subjectivity, to which this book speaks to, so I won't say much more on that. In addition to this, she's a co-editor of the Extraterritoriality of Law, History, Theory, Politics, published with Routledge in 2019. Her other areas of research are in historical materialism and political Marxism in international relations, student politics and protest, and the development of critical pedagogies. She's a member of the editorial board of Historical Materialism and of the Political Marxism Research Group at the University of Sussex. To our first discussant, Professor Claire Cutler is a professor of international relations and international law in the Political Science Department at the University of Victoria. Professor Cutler specialises in the intersections of international law, international politics and international political economy, and is interested in developing critical theory in international law. Her contemporary research focuses upon institutions and processes for dispute resolution in international and transnational law. In particular, she's examining the trend toward the privatization of global governance and its implications for the future of democratic institutions and processes. Among her many books are the most recent of her publications, The Politics of Private Transnational Governance by Contract, and New Constitutionalism and World Order, edited with Stephen Gill with Cambridge University Press. And finally, Professor Benno Teschke is a professor of international relations at the University of Sussex. His research interests comprise IR theory, historical sociology, Marxism, and the philosophy of social sciences. Teshke's core research agenda tracks the historical relations between the rise and expansion of capitalism, war and imperialism, and the development of the European and international system of states. This agenda is informed by a historicist approach to the historical sociology of international relations, international politics rather, which seeks to incorporate grand strategy, foreign policy and international diplomacy into critical historical sociologies of international relations. His monograph, The Myth of 1648, Class, Geopolitics and the Making of Modern International Relations, was published in 2003, and the second edition of his book, published in 2009, was awarded the 2004 Isaac and Tamara Deutscher Memorial Prize. Welcome to our esteemed colleagues. So the format for this event will be for Maya to introduce her book for about 20 or so minutes, and then for Claire and Benno to offer some reflections for about 10 to 12 minutes respectively, and then I'll open it up to the Q&A for questions. So if you do have any questions, do let me know in the chat, and then I'll invite you to mute your mic and address your questions to one or more of the discussants. So I'll now hand it over to Dr. Maya Palm.
Thank you, Tanzil, for that wonderful introduction, and thank you for this series, which I think is going to continue, and obviously to the discussants for being here and all of you. Okay, so extraterritoriality is not simply a technical legal word used by legal professionals, foreign policy analysts and diplomats to usually refer to specific measures taken by mostly states to extend their authority outside their jurisdictional limits. In addition, extraterritoriality, in my view, disturbs and fascinates. It transcends the meaning of its own term of territoriality and signifies a potentially significant role in driving or shaping social change. Extraterritoriality raises the uncomfortable notions of refuge, exile, strangeness or atopia, the lack of belonging anywhere, and of foreign aliens. Not the green ones, of course, but those philosophically or legally categorized as such. Since all these categories are also invoked by the practices of modern bordering, they make extraterritoriality an umbrella concept that covers a wide range of practices that lurk in many of the dark corners of our contemporary order. However, the present work is more concerned with the legal and political truth claims made concerning extraterritorial jurisdiction, and specifically with the historical narratives used to sustain those claims. The spilling over of the term outside those truth claims shows the need to address these historical narratives built by those disciplines and various disciplines and boundaries. The aim is to further open to other, more public and possibly even aesthetic imaginaries these notions of extraterritoriality. Conceptions of power, borders, and territoriality remain continuously disputed on physical terrains as well as on the bodies occupying them, whereas exceptions and privileges of immunity for ruling actors to sustain the emerging form of the territorial state, or as a sense of exile and political refuge in times of total despair, extraterritoriality conveys philosophically a sense of the impossibility of a politically, economically, and legally fixed and closed space. It is one of the main conditions of possibility for a world made of borders, and is therefore necessarily, I think, a part of any revolutionary or radical attempt to contest and change the lethal effects of that world on solidarity and hospitality. So I just kind of positing here some of the reasons why I've been motivated to work on this topic and say something a bit specific about it. So the processes and events revisited and put back together in a specific collage of law, empires, and capital that my book attempts to do constitutes a useful background story to today's explosion of extraterritorial practices, which I leave to many great scholars that are working on these issues today. What I want to do here is summarize the book's key arguments, firstly, and then I want to explain why they matter, and thirdly, emphasize some issues around law and Marxism, which are particularly relevant, I think, to this forum here. So, key arguments. So I put forward 4 historical contributions here, and these form the basis of what I call historical sociology of early modern European imperialism, or we could say legal imperialism, also to be more precise. The first one concerns what I call Castilian practices of jurisdictional accumulation, which could also be called Spanish. I mean, the literature obviously uses both, but I do like to be a bit more precise on this point. And I argue that these Castilian practices of jurisdictional accumulation are characterized as transplants of authority, because they were imposed on indigenous societies as hybrid, organic, so alive, if you want, and so socially wide experiments. Castilian colonizers were concerned with people as juridical subjects and as labor, so as means of exploitation and surplus extraction through political and juridical means. And so I look at the requerimiento, encomiendas, but also audiencias, so these special tribunals in New Spain, and specifically construction of jurisdictional subjectivities in this period, which is quite particular. I also look at some commercial institutions such as the House of Trade of Seville as part of these processes. The second important contribution is, in contrast to these transplants, they're not just exclusive to the Castilian or Spanish case, but they are the ones that are most characteristic of it. In contrast to those transplants, I argue that the other empires I study, so the French, the English, and the Dutch, developed transports of authority. And these consisted in outsourcing sovereign authority to conquer, own, and trade over land and resources driven by commercial interests, chartered companies, and settlers. So here, transports of authority exported and imposed different institutional forms than the transplants, and these often led to the physical and juridical extermination of peoples. Third, following from these two, jurisdictional accumulation emphasizes the continuation of feudal and absolutist processes distinct from geopolitical accumulation up until the 19th century. And obviously we'll, I guess, come back to this with Benno. But the idea is that these occurred in the colonial contexts under consideration, but also in continental Europe through the aristocratization of ambassadors as a strategy of class reproduction. And here I think that distinction is worth making between geopolitical and jurisdictional, and hopefully we'll come back to that. Finally, fourth contribution that I make is that looking at early modern Mediterranean history through the lens of jurisdictional accumulation reveals a contest between complex forms of juridical mercantilisms, mostly operated by what I call overseas or maritime consuls. So I've been fascinated by these actors, these consuls, and that's why I've done a bit of primary research in some French archives for this, and looking at reasserting the role of these consuls as a way of focusing on so-called private or commercial mechanisms, as well as on jurisdiction as struggle between actors looking for opportunities for power assertion and status. And these consuls or jurisdictional actors were said very wide-ranging jurisdictional prerogatives, and that's what's really significant about them. They're not just commercial actors, they're much more than that. So in contrast, the historiography of early modern international law, quote Marx obviously, and extraterritoriality has been too focused on public ministers and public institutions, or, to be public, such as ambassadors and embassies, and as well as on doctrine concerned with matters to be considered public, international, or later. But I argue that there's a need to obviously look at much more so-called private and other mechanisms. Overall, the issues of transplants, transports, ambassadors and consuls show that jurisdictional accumulation presents new actors and legal practices across mostly maritime spaces that were key to shaping the political, economic, and Christian and non-Christian categories of the early modern world, which are still obviously fundamental at this time. It provides a new typology of extensions, transports, and transplants of authority to avoid the false historiographical binaries of firstly the political ambassador versus the commercial consul, which is problematic, and also the other problematic binary of the shift from personal to territorial, as this kind of Westphalian story repeats constantly. So why does this matter? Jurisdictional accumulation is not a story of resistance. It's not a story of a history from below. But I think it's a history of the shadows of empire, of people who contributed to European imperialism. And the point of introducing this concept is to bring these actors, so ambassadors, consuls, merchants, lawyers, out of the shadows and onto the main stage of the construction of modern IR and international law. So I contest two bodies of literature in this, the classic diplomatic historians and more conventional narratives, which I'm not going to go into here. A more thing more of interest is I also contest certain Marxist historical sociology approaches, focused either on world systems theory or on more commercial capitalism models. And and these models tend to see the beginning of capitalist processes of imperial expansion linked to the increased circulation of commodities and of merchant capitalism from the 16th century. And my argument is that both, I think, fail to capture a key process that refutes both of these narratives. Early modern empires, because of their obsession with and the obstacles from jurisdictional forms of expansion through the actors that I discussed, did not give birth to modern territoriality or to capitalism. Instead, these actors, working both for their representatives and for themselves, and that's the key point here, shaped an early modern world that was up for grabs, that was open to possibilities for various modes of expansion and production. And this world constructed its own logic. It was sui generis, rather than simply being a transitional phase between the dark, divided feudal world and this stereotype of the enlightened, progressive modernity. So the process of jurisdictional accumulation adds to existing arguments that international history does not follow clear predetermined paths or inevitable paths, but further contests the consequentialist approach to history. Modern territorial sovereignty was not the necessary and inevitable solution to feudal jurisdictional multiplicity, nor was capitalism the inevitable liberator of feudal chains. And I guess I'm repeating existing work here, right? But I am adding to it by saying that the early modern period was witness to specific struggles that shaped the distribution of authority according to combinations of personal, maritime, and territorial. So the variety of extraterritorial assertions of authority went far beyond the classic cases of ambassadorial immunity or Ottoman capitulations, which is the usual kind of key historical examples you'll get when you talk about early modern extraterritoriality. These form the basis to how these broader practices form the basis to how the contemporary international legal order was shaped both as a limit and as a condition to the sovereign state, right? This idea of extraterritoriality is both an exception and what makes the state, what allows the state to operate. So it helps to explain this paradox of extraterritorial jurisdiction, both exception and condition, and also provides an alternative account to the Pashukanist Mieville version, which assumes a much more consequentialist structural swing from non-capitalist to capitalist, in which the law becomes subsumed without a sufficient account of how that process actually occurs, or I think more crucially, how it could not have occurred, right? Because if we're arguing that capitalism was not inevitable, was not a natural processes, then we need to show how it could have gone otherwise. And we can't, obviously this is guesswork, but that's a really important thing to show. Well, no, there were all these other processes going on, which could have influenced and did influence, right? I think that's a really important part of the story that isn't sufficiently told. So jurisdictional accumulation also provides a more in-depth understanding of the role of intermediary or sub-sovereign actors that shaped imperialism in the period. And by starting from social property relations and moving through various colonial and transnational processes, jurisdictional accumulation provides a new political Marxist approach to early modern imperialism based on what I call method of outward internalism and methodological humility about potential narratives of transition and origins. And I want to come to my final section here, which looks at more specific law and Marxism issues. And I'll transition, no pun intended, but on this issue of transitions and origins. Right? And so I want to make 3 points here on these issues of law and Marxism. And the first one, I want to continue to say a little bit more about this issue of transitions and origins in relation to the more conventional linear narratives. And then I want to say something briefly about structure and agency. And finally, I'll finish with a point about mercantilisms. So obviously, I'm going to go very quickly over these, and hopefully we can come back to them in Q&A. But in terms of transitions and origins, as I was saying, alluding to before, early modern history is assumed to be jurisdictionally pluralist, complex and layered, and no discovery from me there, of course. There's no controversy around the condition of jurisdiction how jurisdiction characterizes the early modern period, right? But what I do, I think, bring to the table here is that this means this jurisdictional multiplicity did not necessarily or inevitably usher into a period of more orderly and hierarchically organized Westphalian relations, right? Instead, jurisdictional accumulation shows, and this is also following the work of many people here, that this period exists in and of itself. It's not merely transitional, right? And that's something that's important in terms of how things could have been otherwise, and how we need to commonly specify what happened with capitalism. In the same way that political Marxism contests commercialization models, assuming path dependencies and natural sequencing from feudalism to capitalism, the approach of the book contests these inevitable and linear transitions from jus gentium, or the law of nations, to modern international law. So trying to bring a little bit this critique to narratives of international law, both classic and critical in some instances. And so this has implications for commodity form theory of law and how we historicize relations between capitalism and law. And Muriel has this argument that the legal form predates domestic law and international law, and capitalism infuses this content of domestic law and international law. And that's, you know, where I depart from him, because we don't get a sense at all of what disappeared, or what else was out there, and what contests are occurring in this period. So my book explores the early modern part of this history to better contextualize the specificity of capitalism, but it doesn't tackle that question directly. And you know, that's something I had to come to grips with gradually. But what I worked out I was doing, what I was trying to sweep or dig around the agrarian revolution of the 17th century English case, and try and reveal the role of legal actors and practices involved in European expansion beyond that case. And I wasn't producing this imminent history of capitalism and international law, and other people are doing that really well, right? So I don't think those exclude each other, but they are both necessary. So the early modern period requires a different set of methodological concepts to do this. So trying to move away from the domestic analogy that I see happening in Muriel, and also the kind of move from singular to plural, and that works well for the 19th century, for a period where we have a standard state form, which colonialism and imperialism tries to emulate, and international is key in this, and work of Dina Tuvala in showing how civilization is part of that process. But I argue that in the early modern period, we need different methodological sequencing. Right? We need to have a different way in which those practices develop. So the other point about transitions and origins is, I think the book could be called empirically Eurocentric, but not methodologically. And I try and spend some time explaining that, and I'm sure I'm going to get some questions about this as well, right? And the challenge was, how do I start from European imperialism, explain something specific about the expansion of European imperialisms, but also at the same time breaking down some of the assumptions that Eurocentrism tends to produce. So trying to be anti-Eurocentric from at least a methodological perspective. So breaking the link from personal to territorial, and also integrating relations from colonial and metropolitan social property relations, and trying to think through those simultaneously. Right? That was really, for me, a key way to try and break that process. In terms of structure and agency, my second point, obviously the role of intermediary and sub-sovereign actors speaks to this attempt to focus more on agency, on specific actors. I think they shape and they contest social structures, or what I would prefer to call that which appears to be structural, trying to break away a bit from these concepts. And a lot of the Marxist theories of law are structural, and that's a discussion I'd really like to have about how people, deal with this issue. So I try and provide something a little different here by showing different imperial facets of the actors of jurisdictional accumulation, how also those actors tend to be severed from economic and class conditions and from each other. So looking at consuls and ambassadors from a class perspective, from an economic perspective, revealed a lot of things that I wasn't expecting. Finally, and I'll finish with this point on mercantilism and jurisdictional forms of capital, and I see some people in the room that really want to have a debate with about this, and the literature is evolving, so I'm really looking forward to continuing these debates on mercantilism, which I'm still thinking through. But the point I want to make here, I guess, and laid out, is that for me, jurisdictional accumulation can be traced economically. That's obviously not what I did. And the reason why I didn't do it was because what was more important for me was creating wealth through the accumulation of rights, titles, and statuses, right, and privileges. And it's acquired firstly through office, through venality, in many cases, or through more autonomous processes, generating revenue and access to taxes on wealth and trade. So consuls are, fantastic example and very rich example of this more autonomous ways of acquiring jurisdiction, and through those rights, privileges, etc., acquiring potential access to wealth. But those practices did generate a significant amount of commercial trade and of commercial capital. But for me, jurisdictional accumulation is not a capitalist process. It did not originate from a direct aim to transform social property relations through economic means. Right? That was only secondary. So jurisdictional accumulation did not aim for the transformation of labour or relations of production through market imperatives so as to produce surplus value from those relations. So obviously applying the political Marxist definition of capitalism here. For me, jurisdictional accumulation established jurisdictional rights and privileges which could only tangentially and only potentially also lead to significant commercial capital. Only in some instances was it linked to the development and expansion of capitalism or agrarian capitalism in England and its colonies. And that's where there's an interesting overlap, which also still needs to be fully worked out. Just to conclude, the early modern was jurisdictional. We know that, but the fact that it was jurisdictional enabled actors to win struggles over access to status and wealth. And that's the key point here, the specific role of jurisdiction and the way in which political Marxism also helps us to see that it's not about just saying that the law is political. It's about saying that in this early modern period, the political is an appearance that is generated by jurisdiction, by an aspect of the law which predates even politics. And I think returning to that says something a little bit different. So thank you. I'll leave it there.
Thank you so much for that, Maya. Over to you now, Claire.
Yeah. First, I'd like to very much thank the organizers very much for this invitation to comment on Maya's volume. And I very much enjoyed reading it and find it to be a rich and masterful account of the origins and significance of practices that we traditionally associate with extraterritoriality in our understandings, both in international law and international relations. The analysis is complex in its multidimensionality, spanning many centuries, many political communities, doctrinal and practical affairs involving evolving historical, political, economic, social, and legal relations through the lens of historical sociology and historical materialism in its political Marxian formulation. This is a lot to say, let alone to contemplate and to write. So it's hats off. It's just a brilliant volume, Maya. My interest was immediately piqued by the opening quotation from a 15th century jurist. An ounce of jurisdiction is worth more than a pound of gold. In fact, I recounted it to my partner, who is a judge in British Columbia and deals daily, indeed hourly, with jurisdictional disputes common in federal states, characterized by multiple divided jurisdictions. It led us on to other notable legal quotations like possession as 9 points of the law, an English saying from the 17th century that similarly identifies legal subjectivity and juridical right with powers of dominion and ownership. The analysis of the concept and practice of jurisdictional accumulation is compelling in many ways in documenting the centrality of private actors such as consuls, merchants, trading companies, factors, and the like, to the expansion of political, economic, and legal empires it really challenges dominant associations of extraterritoriality with the public offices of ambassadors and other political representatives. The case studies of expanding Castilian, French, Dutch, and English empires reveal the neglected roles of what emerges as incipient proto-Therian private spheres, quite before the articulation of capitalism and what is now recognized by distinctions between public and private spheres, politics and economics. It resonates very much with my work on medieval transnational merchant law as a precursor to what we now know today as transnational economic law. However, the analysis reveals the complexity of the processes of extension, transport, and transplant, which are theorized to constitute jurisdictional accumulation. However, these processes of jurisdictional accumulation did not give rise to any clear, unambiguous, or uniform differentiations between now what we know as the public and private domains. The analysis thus brings historical texture and sensitivity to processes that I really believe are useful to contemporary analysis of transformations in the global political economy that are associated with the expansion of transnational capitalism. I would thus like to focus my comments on the contribution of the volume to critical work in international relations. The contribution of the volume to historical sociology and historical materialism in international relations is significant. In a thoughtful analysis, it addresses problems of Eurocentrism in IR theory and provides a robust rejoinder to critics who might accuse the focus on European empires as reflecting Eurocentrism. It advances a compelling methodology of negative and outward methodological internalism as a way of avoiding Eurocentrism, which should be of interest to others concerned with such matters. But the matter did not really concern me, because in situating the study in historical materialist ontology and epistemology of expanding social property relations, the study reveals how inevitably the expansion of empires involves different degrees and conditions of extraterritoriality of social property relations. The focus just happens to be on the European world, but could arguably be applied to the expansion and reception of law and empire globally anywhere. One might think of China today and its expansion throughout the global south. Indeed, I found myself musing about comparative legal work on the reception of foreign law and wondering if these processes of extension, transport, and transplant might provide useful analytical clarity to analysis of the processes by which Anglo-American laws have gained near hegemony in many areas of law throughout the world. Of greater concern, though, to me, is the contribution of the analysis to historical materialism in IR. I read with interest the analysis of my work and will no doubt reread and draw upon Maya's critique of China Miéville's theory of the commodity form of international law. Quite frankly, I applaud Maya's critical analysis of this theorization for taking on a task that I have resisted in the past. I've been asked many times in the past to review China's volume, but I refuse to do so because I challenge so much about the analysis that it would have taken me a book to adequately address the matters, and I simply didn't have the time. So I really thank you for your tight, close analysis here. And I just want to put out three differences, I think, between my understanding and that of Miéville's. Firstly, I think his rendition of the commodity form of law is totalizing, but simultaneously reductionist and ahistorical. And we can say more about that later if you like. Secondly, I reject the association of the commodity form of law with exchange alone. This association derives from Pashukhani's curious and peculiar understanding of private law and its relationship to international law, and is not derivative of Marx, as I've argued before. Indeed, I've spent years trying to show how the international investment regime and global supply chains constituting global production are mechanisms of new constitutional discipline. Under expanding transnational capitalism and the supremacy of contract law as the dominant legal form of global governance. And I would direct you to the most recent issue of RIPE for an article that I wrote with my graduate student, David Lark, who was here earlier, on the hidden cost of law and supply chain governance, Cutler and Dietz on the politics of private transnational governance by contract, and recent issues of the Indiana Journal of Global Legal Studies. Thirdly, I believe that the analysis of law in its commodity form is compatible with political Marxism. It is just one of the various forms of law and is of great importance today globally, but I don't think is hegemonic, but is supremacist in the terms formulated with Stephen Gill in New Constitutionalism and World Order. However, I would like to push Maya a bit to address the specificity of law in jurisdictional accumulation. How would you locate law in relation to capital, in relation to political power, in relation to economic power? You refer to legal means of settlement, jurisdiction as a legal principle, legal domains, legal and diplomatic realms, suggesting that law is somehow separate from and indeed outside politics and economics. Jurisdiction is constitutive, but is law constitutive? Or is it somehow different as a separate domain? References to transitions between legal orders, sites of early modern accumulation, dispossession, and legal ordering suggest that law and legal orders are somehow distinct from accumulation and dispossession, as out there, separate from constitutive acts of accumulation. You indicate that jurisdiction is constitutive of power relations, but is law not constitutive of power relations? Is law constitutive of jurisdictional accumulation? The introduction states that the book's focus is on jurisdictional accumulation as primarily the search to accumulate those functions, rights, and titles as a means to achieve property and sovereignty. But law instantiates those functions, rights, and titles, as too does it instantiate property and sovereignty. So is law prior to jurisdiction and an ontological and epistemological precondition. But jurisdictional accumulation is also referred to as a pre-legal phase. A critical approach to jurisdiction is thus concerned with the de facto pre-legal phase of the enunciation of rules and laws, and its potential for understanding the role of law in contributing to the social construction of major principles of international relations and international law. But what does pre-legal phase mean? Does law pre-exist or follow jurisdiction? I'm suggesting that analytically and theoretically, you might tease out the nature and role of law. In some instances, law may indeed be conflated with jurisdiction. Analytically, you might be trying to stretch the concept of jurisdiction too widely. I think that the law and legal forms require further specification in the constitution of economic and political power and empire. Is not jurisdictional accumulation through extension, transport, and transplant instantiated through laws and legal forms of property, contract, dispute settlement, and so forth? I think that I'll stop here and invite you to clarify for me how and where you locate law in your analysis of jurisdictional accumulation. Thank you.
Thank you so much, Claire, for those rich engagements. Finally, over to Bernard. Ben, I think you need to unmute your mic.
Here we go. All right. Thanks, Tanzel. It's great for being here, for having me, and to revisit a piece of work. And full disclosure here that I actually co-supervised. Is it 4, 5, 6 years ago at the University of Sussex? It's been a while. So Maya, first of all, congratulations for getting this finally published. It has changed, and I have to say in a productive way. And getting it out with CUP is such a prestigious publisher. So it's a great achievement. Congratulations. What I'm going to say is primarily from within the field of IR, and I would first start by saying what I think the main contribution really is to IR, and then I have 3 sets of comments. The first has to do with, it does have to do with method. The second has to do with, tying your story of the agency of sub-state actors in the creation of spaces back to overarching questions of international politics. And the third has to do with debates around England and the specificity of England. And perhaps I could ask you to clarify as to where you stand on the case of England, because I think you declared both exceptional, but then also non-exceptional in relation, in comparison to the other imperial trajectories with which you compare England. So that's the first point. Okay, I take to be the main contribution and the originality of this book really is that you know, this is another break with a standard state-centric rendition of the beginning of, you know, modern interstate order, and you do this by taking this package apart, this package that normally has three parts, right? Sovereignty over territory, right, equals, right, jurisdictional, you know, control. And, you know, the way in which this is conventionally sort of rendered is the correlate of this is to look at how the principle of extraterritoriality is getting codified and institutionalized, primarily within Europe, Northern Europe, as you say, through embassy chapters. And that is sort of broadly speaking everywhere in IR and the standard literature. You know, something that happens not necessarily on that day in 1648, but it has a specific sort of beginning, and there seems to be a systemic transition at play that leads to certain chronological shortcuts and to very sharp befores and after. So I think it's great that you widen the perspective and you bring in actors that are normally never be seen in IR, and you widen the geographical scope, and you bring in the Mediterranean in particular and the Atlantic, and you look at the ways in which these sub-state agents, you know, consuls and merchants, you know, are key, you know, in constructing, right, extraterritorial spaces. And what you bring to the table here is to show that it is never easy just to project sovereignty abroad, right? This was never simple, you know, a state-led process, a simple imposition inside out, whereby foreign territories were assimilated or incorporated into some kind of pre-existing notion of stable state sovereignty. So I guess methodologically, the whole emphasis really is on construction, right? On the open-endedness of these experiences. Okay, quite in contrast to what you consistently critique, namely any sort of theories or models in IR or international law. We talked about Pashukanis and Mieville that look at history, right, primarily in terms of structural derivations. Okay, so within law, and you see this also within IR, there's certain logics to all the work of explanation and agency subsumed under logics. You turn this around, you foreground agents, right, that construct their strategies as they go along. And much of what you say, and I think that's the interesting thing, is you know, how dissimilar the outcomes were when you compare these four different case studies. Now, this, of course, is the shift towards historicization and an agentic account of international law is always a messy thing to do, right? And, you know, what Claire calls the richness, right, can easily, I think, also be read as, you know, the difficulty of really getting a grip methodologically on this highly rich and super rich historical material, which I think is a joy to read empirically, but then there are follow-up questions as to how does political Marxism get a handle really on these things. And the standard analytical answer is, right, there's this tripartite step. You start with social property relations, they are contested, right, you bring this to life. These are the key classes, the key actors that contest this. They bring in authority relations, that is state forms, right? And they also tell us something about the way in which, you know, extra-European territories are incorporated or not incorporated into formal domains. And that's fine. But on a higher level, you say, right, okay, so this is about a method that you call negative and, what is it, internal methodological internalism.
Outward internalism.
Outward methodological internalism. And again, that's great. So you start with the domestic and you trace, right, how these things are being, exported abroad. It just seems to me that, once we then read the empirical case study, that you then relapse into, what looks like a comparative history, right? Four imperial trajectories that run more or less in parallel, right? And when you sort of make empirical references to how they are influencing each other, these empirical recognitions are not necessarily reflected in and captured by this method of outward methodological internalism. In other words, I do think it is necessary to close this gap, right? And I think it needs to be closed in two ways. The one is, I think we need to somehow recognize, in terms of research design, the inter-imperial, right, relations between these polities as they project abroad. I mean, we know that this is a story of war, of almost constant war, but not only war. The second point that speaks to your handling of Eurocentrism, I think we also need to somehow, recognize, in terms of research design, that's a periphery, if you want to use these terms, right, also needs to be actively, incorporated, as a voice, and not just, an empty space into which, European or imperial experiences are projected. This is incredibly difficult to do, and it's already such a, methodologically challenging, right? And you are really struggling with these issues. But I think for an international historical sociology, I think, we need to be careful, right? Not a priori, right, to somehow sort of bring in comparative history and internal out, not only in terms of domestic, international, but also Europe, non-Europe. I think that legacy, I think, is still there and still hangs there. The second point I wanted to make has to do with, this is not, as you say, history from below. It's not the history of contestation, but it's somehow you go a level below ambassadors and public agents, and you really excavate and bring to life what's very difficult to conceptualize, right? I mean, Claire sort of said, this line between the public and the private is very often blurred. You got these hybrid actors. Nevertheless, I mean, I'm just asking myself, and perhaps asking you, or reminding everyone, right, that this is about the construction of spaces. Some of which are very small. I loved your example of the ale houses in the Maghreb, and that here are the Germans drinking and here are the British drinking, and so that's great, okay? But all of this, of course, happens, within a wider political geography that throughout the 300 or so years that you cover, right, is being organized and reorganized at a superordinate level, namely at the level of international politics, right? So what I tried to convey is that I was missing, a more direct, recognition of the fact that these four imperial powers that do not just in parallel, right, stride out, but that their histories, right, at crucial points in time is not only about constant warfare between them, come together, sit down at the table, right, have major summits, major peace congresses, where they lay down new political geographies and new principles of international conduct, right? I mean, it comes a little bit from the outside, but I think, given that there is this superordinate, constant, attempt to order international relations, right? I mean, I think these ordering mechanisms and their political geographies, I wish they would be a little bit more visible So that you could then say, okay, and within these newly changed spatial orders, right, these consuls do this and that and the other, to make this more visible, to bring it out more clearly. So what I have in mind, right, I mean, Treaty of Tordesillas, between the Portuguese and the Spanish, they divide the world amongst themselves. It's still a papal mandate, right? Does that matter for your story of how the Spanish case unfolds, right? 1648 Westphalia, hardly about colonial matters, true, but there are other treaties, right? Treaty of Utrecht, I think it tells a story roughly until the 18th century. The Treaty of Utrecht, in contrast, is of fundamental importance, right, for dealing with the colonial question, for dealing with European continental order, and, you know, for demonstrating how central Britain really is in managing and reorganizing and orchestrating this international order. And by extension, and that's perhaps a little nod to Wilhelm Greve, of all people, I didn't get much of a sense that, you know, within these four cases, that powers are rising and falling. Yeah. So it almost seems as if, you know, the Spanish, they're always right, and the Dutch and the French and the Brit, of course they are always there. Yeah, but it's still the fact that, you know, there's a Siglo de Oro, which is Spanish, and then the French are, you know, under Louis XIV, they assume a quasi-hegemonic position, and then the British do take over, right? And it seems to me that this is, you know, bringing in the issue of power, you know, I think would be crucial for slightly retelling the story in which, right, these four polities, you know, could do imperialism and could do colonization, including, of course, you know, look at the fact that, you know, France was nearly obliterated, right, in the 18th century from the North American context. This is not just to add complexity it is just to make this a little bit more visible, these micro aspects that you bring out, and how they're situated and embedded within this wider geopolitics of spatial reordering. The final point, you know, has to do with Britain. And, you know, it's for the audience, right? I mean, you know the argument about how much PM, how much Brenner and Wood, and I myself include myself here, you do single out as Britain as being the first state that has made the transition towards agrarian capitalism, you know, based on very specific resolution of class conflict and so on, whereas in most other continental states, that transition didn't happen. The Dutch is a contested case. I would concede that, you know, there are pockets of capitalist activity in the Dutch Republic, but they're not so strong in order to really alter, right, the nature of the Dutch, you know, state. It's still, you know, an oligarchic merchant republic, right? It's nothing like a parliamentary constitutional monarchy is in Britain. So wherever we stand on this issue, on how different or how exceptional, you know, Britain is, I would say, right, it is exceptional in relation to all of these other continental states, but it does not mean that it creates a new norm, right? Its form of statehood and colonization, you know, it's, as you rightly say, this is not a new norm. We're not looking at the process of converging towards, right, in an isomorphic way, the institutions of British economy and the British state, and yet Britain is exceptional. I was just wondering, because what you say empirically is that you group France in the Atlantic, the Dutch Republic, and Britain, you know, in the category of, it's not transplants of authority, but it's transport, right? And by transport, you mean these states are required, right, to outsource jurisdiction to the semi-public agents, And to this corresponds, broadly speaking, the notion of dominium, not so much imperium, right? Dominium as control over, not over property, not necessarily over people and land. Okay, you're the expert here. It just strikes me that if you look at North America and what the British do there, this is a colony, right? This is a formal part of British sovereignty. So it's not, as far as I can see, you know, if you look at the eastern seaboard, you know, it is not somehow private power operating there. It is private power operating there on behalf and always under the authority of the British Crown until, of course, US independence. Okay, that's all I have to say. Thanks, Maya. And yeah, looking forward to what you have to say on these points.
Thank you.
Thank you so much, Benno, for your rich reflections on that. We will now go over to the Q&A. We have a question from Carl. So Carl, can I invite you to unmute your mic and direct your question to Maya, please?
Yeah, thank you very much for an interesting presentation and discussion. I've actually started to read your book, only 100 pages so far. But I would like you to expand a little bit on the distinction between consequentialist and agentic processual approach to law-end capitalism and law-end history. Because I think it's a little bit unclear whether you argue against consequentialist approach in general. You write somewhere that you defend the processual agentic approach rather than a consequentialist approach, and there are also the closely related concepts such as this synchronic approach versus diachronic approach, and also the question about transition to capitalism versus general characteristics of law in relation to capitalism. But at other places in the book, and I think you quote Ellen Maxis Wood arguing that it's important to focus both on structure and the specific historical processes. So I mean, my first question is if you want the reader to interpret your argument as an argument against consequentialism in general, and if that is not the case, I have a follow-up question as well. Then I wonder if you think that you really, I mean, your activation of political Marxism against the commodity form theory of law, if you think that, I mean, because I take Pashukanis to be mainly interested in the synchronic dimensions of the legal form in capitalism, thus he's not asking questions about the transition to capitalism. So I wonder if you are not arguing against consequentialism in general. Do you think that the focus on the transition to capitalism found in political Marxism is effective to criticize commodity form theory of law? Yeah, I hope you get what I'm asking for. Thank you very much.
Maya, if you want to take that question, and I would encourage others to let me know if you do have a question for Maya or any of the other discussants.
Okay, thank you so much, Claire and Benno and Carl as well for your comments and questions. And I'm not going to be able to do justice to all of them here, but I will definitely come back to them as much as I can in other forums, I hope. And I mean, generally, they're going to really help me to, think through the process. What's been, really interesting about preparing for this and generally, rereading the book and what I've written and trying to think through and clarify still some of the issues that came across. Dealing with so much material across such a long span has made it incredibly rich and exciting project, but it also means that things are constantly coming back up, and I'm constantly questioning, obviously, ways in which I grapple with all that material. So this is really helpful. Maybe I'll tackle Carl's question first, actually, because it kind of lays the ground a bit for some foundational points. So I don't want to argue against consequentialism as being a part of historical sociology or of analysis that should never be undertaken, right? It's not. That's the point I try and make about methodological humility, and there's been a lot of interesting work trying to argue this point about methodological choice. So Sam Naffo and Benno as well, to some extent, have written about this. And for me, it's really important that we don't play this game of one method evincing or excluding all others. So, I do want to make that point. So it's not, I don't want to present a book that says this is how it's done and no other methods work. But for me, that goes completely against the concept of method and how we should approach social science generally, but even more so historical endeavors. However, obviously, this book is definitely a critique of consequentialist approaches to history, and I would, I definitely position myself and this particular project in that critique. And what I mean by consequentialist, and I guess Ellen Wood used that term, and I'm sure we could probably since then, elaborate and with more nuance about these issues. And it's, it's reductive to some extent to just class people into either consequentialist or agentic. But, for the sake of the discussion, the point is to say that consequentialism assumes the outcome, the end point of a particular historical process, and retraces back the historical steps to that end point. Right, and only focuses on what produced that end point, i.e. capitalism. I'm interested in not doing that. I don't want to focus solely on explaining what produced capitalism or how capitalism is the mechanics of it in, as you said, the general characteristics way or in an immanent way. That's not what I'm interested in doing. I'm not saying that's not possible, and of course, most of the work done around these topics are interested in that. I want to do something else, and that something else is not completely separate from those other aspects. So I hope that helps clarify a little bit. And so at the same time, I don't think it's just a work of transition. It's also about situating a specific space and time and trying to say something about that space and time, but trying to think also as that space and time in relation to today. And Claire's comments are really helpful here to try and think, well, and these are the kind of questions I'm asking myself now. What is happening to jurisdictional accumulation today, or even the 19th century, before I even get to today? But, what happens to this process in the 19th century? And that's a question that I'm not sure if that's going to be the next project, but it's part of, obviously, what I'm constantly thinking about, and how, if I'm looking at a process that wasn't necessarily developed by capitalism or wasn't pushed by capitalism, and I'll come back to the point about British exceptionalism here in relation to Benno. What happens to it, right? And does it survive? How? There's obviously it's very tempting, and Claire's work's been really useful in doing that, to try and think through these processes today and how they reverberate or continue to entangle and show processes of contest. So, I don't know if I want to use jurisdictional accumulation for today. It's very tempting, and part of me wants to, but I also want to be careful about just transferring these approaches. So that's where I would, even though I developed this diachronic approach, I don't want to also just use these concepts transhistorically without really careful analysis. I think political Marxism is effective in criticizing commodity form theory. Absolutely, I think, and that's not about also saying that commodity form theory is has no use or doesn't say something absolutely essential about law today. And Claire's points are really taken on board. I do need to do more reading up on more recent work on this. And it's a field that's really evolving, hence this workshop, right? And I mean, the work of Rose Parfitt, the work of Dina Zavala, Rob Knott, you know, trying to develop, of Geertje Baals, trying to develop much more nuanced applications of the commodity form theory of law. So I'm definitely, you know, I don't want to denigrate those approaches and those applications. However, as you know, right to say, that wasn't Pashtukanis's goal, and I think it's been. I think the problem is that Miéville's work, which is quite historically nuanced in some respects, right? So it's not just he, but it's easily taken as a structural overall critique, which doesn't do justice to the actual processes and to how things could have occurred. And this the importance of understanding capitalism as a specific process that coexisted with other processes, and to try and think through how that process could be otherwise and could have been otherwise. And for me, that's why political Marxism is so rich and interesting. Right? It has that more politicized, if you want, objective as well, right? And yeah, there are aspects of Ellen Wood which are structural, and Benno's recent work on this, and we've got a symposium coming out in historical materialism which is going to discuss all this in detail. So yeah, I'll refer you to that in terms of some of those maybe contradictions between some of the earlier political Marxists and work that's developed today in more kind of agentic dimensions. I'm going to try and maybe pick a few things from Claire and Benno and then open it up to more questions. Claire, you've really, I mean, that's really a great point about trying to better conceptualize the law, in relation to jurisdiction. And my baseline in the book is to argue that what interested me in jurisdiction is that it was a practical process, a process that referred to how agents were not imposed a specific set of practices or rules, but were creative in the way in which they developed legal processes. So there is something for me about jurisdiction and the work of obviously Shauna Dorset and McVeigh on this is really useful, and other people since, right? There's a lot of kind of critical work on this issue, and Sunja Bahuja obviously has been really useful to try and think of these jurisdictional conflicts or disputes as primary to the establishment of legal institutions such as sovereignty. And so I can't claim to cover and explain everything that the law conveys, right? I mean, that's for me seems an impossible task, but I definitely take on board that, you know, what I was saying at the end of my presentation about how we think of the political, for example, and how we think of these concepts differently depending on periods in which they emerge. And this links a little bit to the rules of reproduction debate, but I'm not going to go into that. But I do think that jurisdiction and how legal institutions, to try and bring it down, emerge from specific jurisdictional practices are specific to those practices. And for me, it doesn't make sense to talk of the law transhistorically in that way. Now, I think that's what Pashtukanis and Miéville do by using the legal form, even though they then qualify that. But I think what interests me in this pre-capitalist phase of jurisdiction is that process is still much more malleable, and in a way that there's also more multiple notions of the law. And if you look at the differences in France and Spain or Castile about what the law is meant to do, how, for example, the Castilian monarchy is shaped by ethical, moral conceptions of the law, which are very different to how the law becomes, it is divided in France into parliaments and specific actors which represent the law. So again, I struggle to really use these terms across empires, because in each case that I look at it, they mean really different things. And that's how my project started, to try and think, well, how did these different legal systems emerge, and kind of, got sidetracked. But So yeah, I think I can definitely say more, but I also want to a little bit resist and bring it, you know, nobody talks about jurisdiction in IR, and I really wanted to bring that concept to the fore and explore it and dissect it and think, what can we do with it? What more, you know, what can we reveal about the history of IR and international law by focusing on that concept? Benno, yeah, I can't deal with all of that. That was so rich, so thank you. And I know this is, you know, a conversation we're going to continue, hopefully in loads of other fora. But on the point of treaties and this superordinate level, I think I quite fancy trying to have a go at that. I mean, obviously, this was what I was trying not to do in a way, right? I didn't want to write a history of treaties. That's what I've been reading in all the histories of international law. So I definitely wanted to move away from the ways in which legal practices through diplomatic and sovereign relations were being crystallized into institutions that would then form the basis of later enunciations of international law. So these benchmark moments and events, I wanted to move away from that. So that is a conscious thought. And obviously, yeah, this was never going to cover all those aspects. Whether that means there's missing now a construction of, there's a missing level of how this is coordinated. Yeah, I mean, looking at, for example, ports. So I've started digging into, you know, more merchant relations between merchants and consulates and like the House of Trade of Seville, these commercial institutions, and the networks and links that, and you know, you start looking at early modern history from a really different perspective, and so that coordination between specific merchants for me was really fascinating, and I would have liked to go more into that. So in a way, I would be more interested in looking more at those types of coordinations which we generally tend to talk about, and see how they affected and how they kind of have, in a way, in how Claire explains it, goes back into transnational merchant capitalism and how that evolves today. So yeah, I take the point about the rise and fall. Yeah, definitely. I mean, there's definitely missing stories there. I mean, how Spain becomes subsumed by the French monarchy, and you know, how I constantly grappled with my distinctions of the French, the Spanish or Castilian, and the English British, and how that closed doors. It was constant compromises, and I don't have the solution to how we avoid these. But and just a couple of points on Britain. Is it exceptional? I mean, obviously, you know, how, as you know, if we say it's exceptional, then what is not exceptional? And the whole point about, for me, that period was to say that it was all up for grabs. You know, there was still so much potentiality in how things could have gone. The point specifically about what I think is qualifies the British colonies as transports and as similar to the French and Dutch cases is that there were significant conflicts between actors in the courts, in the Privy Council, in even the governing boards of the companies involved, and a constant legal processes of trying to separate themselves. So you have obviously the Calvin case is a classic case, but later also disputes, and there's a lot of legal historians working specifically on this to show in the ways in which there was this constant layering of decision-making processes and control over what was happening in some of these territories. And I do think that is significantly different. Obviously, these are, you know, I'm going over a lot of nuances in these processes, but I still think it justifies associating what Britain's doing. But again, you know, a lot of the lawyers and colonizers that were going to the colonies were also involved in agrarian capitalism processes in England themselves. So they were capitalists or emerging capitalists as we would understand them. So that's where it becomes really messy for me. You know, are they doing more jurisdictional accumulation or more primitive accumulation? And that's, for me, that's where I'm on shaky ground. And that, you know, I think that probably requires more in-depth historical research on these specific people, what they were doing and why, right? If that's what we want to find out. All right, I could go on forever, but I'll leave it there.
Thank you very much, Maya, for masterfully going through, responding to the discussants reflections and to the earlier question. We've got about 15 minutes. Ronald, can I invite you to ask your question, please?
I think just the shaky ground, as you describe it, Maya, seems to me quite interesting in the sense that if we take Benno's question about sovereignty and cuts across Claire's distinction or questions about law, then the question of outlawry becomes interesting to me, and the figure of the rentier, and the, everything from the pirate gaming the flags. So it's not true that because one sovereign is rising or falling, these players seeking jurisdictional affordances are following one flag. I mean, so it raises a whole separate sphere of potentially of agency, and that carries all the way through to your Goldman Sachs private equity unit in Greece, or choose your country. And it seems to me to enrich sovereignty by demystifying the bottom up and top down dichotomy in really interesting ways. And it adds another piece of that. So for instance, by the time you get to Cecil Rhodes, he's the governor under the British, but he was doing deals with the Afrikaners to game the Queen, right? So, and you can find that people building agency in those ways as part of what constitutes the rise and fall that Benno speaks about, I guess. And so, yeah.
Maya, I don't know if you want to respond to that question, comment?
Yeah, I mean, it was more of a comment, I guess. So, but it's just making me think a lot. Again, I mean, I'm definitely very shaky on making these links to contemporary cases, because I just, I just don't think I'm properly placed to make them. So, I found what you're saying really interesting and need to look more into it. I definitely can comment more on the outlawing and rentier aspects, especially at the time. And well, obviously the process of privateering in this period is characteristic of these ambiguous public-private processes of, I guess what Claire was saying about proto-private, which is an interesting way of putting it, and just thinking of how sovereigns were caught in all these processes as well, right? So the fascinating debates on how to deal with privateering on the North African coast, with to the case of the Dutch. There's Erika Heisen-Roach, I think her name, that's doing work on Dutch consuls and Dutch captives and all those processes, and the complexity of the conflict, of the conflicts, but of the alliances between either the different European empires at play there, or the different rulers, whether Ottoman or not. So obviously Morocco not being part of Ottoman rule there, but having specific jurisdictions in place, and so all these different alliances. And it makes the story of these neat empires ridiculous when you actually look at the reality of these specific processes. So again, they're not clear-cut categories here, right? This outlawing or lawyering in many ways. They're being created. That's the point of jurisdictional accumulation, that these processes are really malleable, and maybe we could argue today as well, right? The way in which certain trading financial mechanisms or even judicial mechanisms are being held behind closed doors, are not processes that we have any accountability over, and so they are up for grabs, right, in that sense. But yeah, I mean, a lot for me to think about, I guess.
Maya, I wonder if I may disrupt my position as chair and ask a very, very brief question. Thank you so much for your erudition of your work and your responses to the questions and comments. So, this work as you say, primarily focuses on sub-sovereign actors which contest structures. And one of the things that you focused upon, and you said that you develop, and I'd invite you to kind of explore that a little bit more, is how this work responds to structuralist theories of law and Marxism.
Thanks, Tanzil. Yeah, I'm trying to think also how it might relate to some of the questions of Benno and Fred I didn't get to, but and perhaps this question of method to some extent, right, and the point about relapsing into comparative analysis, which I think I need to tackle. So, I mean, I think it's been interesting reading a lot of and I'm still got a lot of catching up to do on the most recent debates and books that have come out, right, and the reason why that's motivated these series. And I mentioned the work of Rose Parfitt, which I think is really interesting because she she argues from a very completely different standpoint of international legal reproduction and how legal subjectivity and individual legal subjectivity is imposed through the state and through this international process of reproduction, right? So it's kind of the reversal of to some extent what I'm trying to do. And so I can see that, for me, that's a structural process, and she argues for that. It's based on Paschal-Kernes and Althusser, and there's, I think, Dina's work also alleges heritage to Althusser and perspective. So, this is for me completely opposite from where I've come from, which is a critique of these positions. But, I think it's really rich to see how the completely different questions they ask and where they get to. And I think, and I make this point to some extent with, for example, the work of Pepijn, and I'm probably cruciating his name again, Brandon, on the Dutch case and its war capital and the Dutch state. I think trying to think through, the Dutch case specifically, and Benno mentioned the issue of pockets of capitalism there, but trying to think of what, how do we talk about concurring or competing processes which had similar conditions to the case of English capitalism, of agrarian capitalism, but then through other variables developed different outcomes, right? And again, so the question of structure is which are the structures that tend to force those conditions, right? And what are, for political Marxism, the rules of reproduction that will determine changes. I think the way in which La France and Post put it is, we need a concept of rules of reproduction to understand how we can exit into a different mode of social property relations, right? And so that's the kind of structural aspect of the mode of production, or broader social property relations in a more structural sense. Now, my work wasn't interested in figuring that out. I was interested in understanding specific practices between actors that defied those processes, and that tried to, I thought was, the hypothesis was that they were mapping out a different modes, and I'm still hesitating between calling them structures or modes. And there is a tension in the book of, I think, because it took so long as well to process, and how I went from a maybe more structural process at the start to a less structural one. So I think there's going to be much more nuancing in how we talk about these things in the future, and I'm just really interested to see the debates with Dina, Rose, Rob, and Chrétien, and everybody else. I'm forgetting loads, Umut, etc., who are developing all this stuff. It's such a richer field than when I started the PhD, which, Benno, I don't want to make you sound old, but 12 years ago, rather than 4 or 5. So, it's been really fascinating to see that literature evolve. But I think I'd say in my presentation, I'd like to see it more as that which appears as structural. I don't think we should take what is structural as in essence, and we need to constantly contest the construction of those structures and how they appear to us, because they are appearances. And I do want to ground myself more in practices of actors, because for me that's more the starting point to what I'm trying to do.
Thank you so much for that, Maya. I think that we can bring proceedings to an end. Unless, Maya, you have any other concluding comments or reflections that you'd like to make?
No, I mean, I could go on forever, but I'm really appreciative of people's time, and it's late in the day. And so I know I'm really pleased, and I'll come back to all the points I failed to respond to, and look forward to discussing them again. But yeah, thanks to everyone for listening and for your comments.
Well, on behalf of everyone, the participants, we'd also like to thank you, Maya, especially for allowing us the privilege to be the first launch of this fantastic monograph. So I'd like to thank you, Maya, our discussants, and also to our participants. Details of the series and of the book are in the chat function. And we'll also be sending out a recording of this event. So thank you very much all for coming, and we shall see you all soon. Take care.